Next concept is the advocacy and elements of advocacy. Advocacy is a skill. Advocacy can be both written and oral, and in actual fact, it encompasses a whole range of skills which are invaluable to lawyers. An advocate is a person who argues in a favor of his clients in a court of justice. Section 2 clause A Section 2 clause 1 clause A. Advocate means an advocate entered in any role under the provision of the Advocate Act 1961. So advocacy is a skill and it can be in both forms, written or oral. Elements of advocacy. First is to accept brief in the court. Second is the filing the case. Filing the case. In civil cases of a suit is required to be instituted by presenting a plaint in the court. The plaintiff presents his case along with the cause of action through the plaint. Plaint means is also called a written statement. The object of the pleading is to make both the parties aware of their cases and allegations against each other. Suit is commenced by the presentation of the plaint. Means first is the accept the brief in the court, second is the filing the case, third is examination in chief. It is the way in which the advocates present almost all the evidence through the witness. Then cross examination. It is an art and it is learned from the experience and from the observing senior advocates while cross examining witness as well. Cross examination of witness is a procedural matter. It should be done according to the provision of the Indian Evidence Act, Civil Procedure Code, Criminal Procedure Code, and the provisions of the law. The opponent advocate should not interrupt the cross-examining advocate. It is a right of an advocate, but it should not be misused. Next is the re-examination. Re-examination is a final part of questioning of a witness at a trial following their cross-examination. The main object is to explain the points arising out of a cross-examination.